So Tom is from Denning Health, graduated from Dalhousie University, or Law School in 1992, and since 1995 has been involved in the development of drug and alcohol policies for companies across the country, including those headquarters south of the border. Tom's focus has been on the timber industry, but he has worked continues to work with a wide range of industries, including those involved with telecommunication, commercial transportation, bus, truck, and aircraft, construction, and resource extraction. Drug Testing 101, the title of Tom's presentation, will cover the highlights of a successful drug and alcohol testing program with hard-hitting points which will resonate with owners, managers, supervisors who face increased penalties for work site safety breaches, including criminal prosecution via the Bill C-45 and increased penalties under the Workers' Compensation Act. So without further ado, Tom Yearwood.
I'm very happy to be here and thank the BC Forest Safety Council for inviting me. Things I promise you this morning is I'll tell you the truth as I know it. If I give you an opinion, I will differentiate between my opinion and what the law says. If you have any questions, I guess we can use Pigeonhole. It's a great tool. If you have any questions, you can shout it out at the appropriate time. It may be that I'll defer you till afterwards, because the amount of information that it has to be conveyed in successfully launching a program, such as drug and alcohol testing, is very comprehensive. It's very detailed, and you have to do things correctly and properly. Anybody here done scuba diving? Skydiving? Skydiving is a really good parallel, because it's very simple. Gravity takes over, you jet out of the aircraft, and you fall. If you make a mistake, the consequences are rather dramatic. So it is with drug and alcohol testing programs. I'm not sure. There we go. A bit of background, and I will go very briefly over this. I've been doing this since 1995. We have well over 600 corporate clients involved in all sorts of different industries. Starting off in terms of the timber industry was in 2000. We got the contract for Weyerhaeuser. So they really cut the teeth, took the leading role that many years ago. Since then, a number of other companies have really stepped up to the plate, and Interfor being among them. How many Interfor folks are here today? Okay. Western as well is a client, and how many Western folks are here today? Okay. And Island Timber, Timber West, Lamar, Wacash. Okay. So a lot of the folks have been, in the room today have had some introduction to the topic, but we're going to, as I mentioned, get down to some nitty-gritty stuff about workplace liability. That of my background, by the time I went to law school, I had worked in construction. I had worked as a truck driver, one of my favorite jobs, hauling B-train in Alberta. Had done a number of different industrial-oriented, safety-sensitive positions. Many of the people I went to law school with have never worn a hard hat. They've never run a chainsaw. They've never run a jackhammer. They've never poured concrete. They've never fallen a tree. Why does this matter? Why am I up here saying this? Because everyone in this room has a heck of a lot more knowledge about what goes on in reality and safety and the practical aspects of operations than many of the people these days who are now becoming arbitrators and judges. And this is I'm going to come back to this and make it relevant when we talk about the investigations and workplace accident reporting. The need to paint the picture properly for the folks that are going to be making literally decisions about possibly your liberty that have to be addressed. Okay. So, substance abuse is a threat in all workforces, all work sites. And it isn't always this easy to spot. If it was, well, it would be a much easier world. So thinking that I only had 40 minutes, these are the topics that I decided to canvass and cover. And so what I'm going to do is roll through them, and I invite questions at this point. I don't know, Gerard, is it appropriate to do the pigeonhole stuff now? Okay, sure. I guess one of the things I did want to do, though, is get medical marijuana out of the way, because what I've learned over the last many years, and especially with it being legalized, or impending legalization is that I want people to be able to put that aside long enough to hear the rest of what we're going to talk about. But medical marijuana is a big issue, and legalization of marijuana is an issue. But what we're here to talk about is workplace safety, and impairment, regardless of the cause, is the issue, not how you got impaired. So alcohol is legal. Oxycontin prescribed by a doctor is legal. It really doesn't matter whether it's legal or illegal, it's whether or not you're impaired on the job, whether or not you're fit for duty. So for those of you that have that burning issue or desire to talk about that, we will defer it to the end. But I just would like to invite you to put that aside for now. So, is drug and alcohol testing legal? Yes, it is, absolutely. Unfortunately, there is no legislation in Canada right now that dictates that you are to do drug and alcohol testing, or that you can do, unlike in the United States. People often want to know what the cost of rolling out a program is, and depending upon the scope and nature of the program that you adopt, that will dictate the cost. But typically for companies, they will achieve a dramatic reduction in workplace accidents, and that in itself pays for itself. It'll pay for the program. The cost of not rolling out a program, well, we're going to talk about that today. With the adoption of contractor requirements, which Interfor has done, and the other major companies on the island are in the process of doing, within I'm not sure what time frame, a year, realistically, you may not be able to even bid on work for these companies unless you have a program in place. It's going to be a requirement of the major players that each company, each contractor, has their own policy. But even, so if you're a small contractor, one or two persons, or you work infrequently, while you may not be required to have your own policy, you will be subject to the requirements, meaning you have to meet the expectations of the major leaseholders. Where we go, oops. So, this program, in terms of explaining it, rolling it out, usually it takes a day, 2 days to get through policy and supervisor training. Because of the limited time we have this morning, we don't have the time to try to reason through this process. So I'm going to make stark examples of workplace safety failures and the consequences. Now, I'm not up here telling anybody in this room that drug and alcohol testing is going to solve all of your workplace safety problems. It won't. It will address the concerns that it is intended to. It will increase safety, it will reduce workplace accidents, but it's not going to stop illness, head injury, fatigue, mental illness. It will not address the other factors that related to safety. It's a very targeted approach. For those companies that have gone through it, I'm sure you'll agree, though, that adopting workplace drug and alcohol testing is a game changer. It fundamentally changes, in many ways unexpected, in fact, the way that you look at your organization and say, okay, I got a question for you. How many companies in the room here represented, how many people buy alcohol for your employees or your clients? Anybody? Come on. How many people here drink? Oh, there we go. All right, so we're going to get back to that because I have a little bit of extra time. We're going to get back to that. We're going to have a bit of fun and maybe at other people's expense, but I'm hoping that 2 takeaways. One is you got to take this topic very seriously. B, if you're a contractor on Vancouver Island, you've really got no choice. And that may sound harsh, but the fact of the matter is the majority of the people in this room are managers, owners, supervisors, and each one of you could face jail time, face bankruptcy as a result of workplace accidents. So are all workplace accidents related to drug and alcohol? Absolutely not. I'm not here saying that. It's a tool, it's an investigative tool to address a specific risk with a very high degree of effectiveness. Okay, anybody here heard of the Metron case? Obviously the people that sat through my 2 days of torture have. All right, so Metron, it's Christmas Eve, 2009. So you can read that. And the Is this red button the back button? I'm kind of afraid to press it. Anyway, yeah. So Christmas Eve 2009, 6 people on a scaffold, 10th floor, 14th floor, a long ways up. There are 2 safety ropes. Anybody have a problem with this so far? Okay, so post-mortem assessment of the individuals working that day were that they had smoked marijuana recently. The fact is, though, the Crown, the government, didn't make a big deal about the fact that they had smoked marijuana because for them it was a red herring, it was immaterial because of the way Bill C-45 operates. But if you read the cases and you read the commentary from the lawyers and pundits, you'll read into this that the folks that day, it seems to me, got high, up on the 10th or 14th floor, made some really bad decisions that resulted in 4 people dying on Christmas Eve. Pretty horrible situation, eh? 2 safety ropes. The court found in this decision, and I'll just actually step out for a second, backtrack for a bit. So this is the criminal code definition. So you read that and see whether or not you fall into this category. If you fall into this category, you are liable. Life in prison, that's for a death, 10 years for bodily harm. So we heard her this morning and the horrible situations that have taken place, the 25 deaths in the last year. Some of those were occupational illness, but the work safety ones are worksite ones. And the way things are working these days, investigative process, this is a target and focus of investigation procedures adopted by the RCMP. Okay. This touches and concerns most of the people in the room. The individual involved in the Metron case, it was a company out of Toronto, and the supervisor, and this is from the Court of Appeal decision of Ontario, a very high-ranking court, they recognized the fact that this supervisor had a stellar safety record, that he was a man of good character, married with 3 children. He went to jail for 42 months, prison, okay? His company, Metron, was initially fined $200,000. On appeal, the Crown appealed that, and the Court of Appeal found that it was manifestly unfit. They fined the company into bankruptcy. The defense argued that it was unfair, that the company simply could not pay that increased fine, and that it would put them into bankruptcy. The court went out of its way to point out that the ability for the company to pay was not something that was relevant or for the court to consider. The ability to pay was not something that the court would consider, because the reason they have the law is to deter people from engaging in dangerous activity and to punish those that do. Okay, so that company went out of business. The director fined $90,000. The director, who wasn't on the job site, still found guilty, and that's the way the law operates. So he was found guilty, fined $90,000, and the company cannot pay that fine. That's the way the law works. The company cannot indemnify directors, owners, officers for fines that are levied under Bill C-45. So very serious stuff, right? So I'm not up here trying to scare you. I'm up here indicating and letting you know that this is a whole new ballgame now. Is that workplace health and safety has taken on a much more serious tone in terms of investigations. I'm sure everybody here is familiar with the Queen of the North. So that fellow apparently engaged in things he may not have or shouldn't have been while he was at the helm. And the Queen of the North hit the island, and 2 people are missing. That fellow, 42 months prison term, and he barred from his profession for 10 years once he's out of jail. Prison, in fact. Okay, so that's a local case. It is becoming more frequent, and as because of the change in the way that WorkSafe is investigating and the involvement of RCMP, when there's a serious injury or fatality, they are going to be called out. You can expect them. So I've already mentioned this, right? 10 years for bodily harm, life in prison for fatalities. And the fact is, what the Crown is doing is using the threat of Bill C-45 as a tool to get admissions of liability under other laws, occupational health and safety laws. because folks that are involved in the process will take a bite of the provincial penalties are more inclined to do that, and reasonably so, than they're going to admit to criminal liability under C-45. So, some questions for you. And again, we don't know each other all that well, but after the 2-day session, everybody loves me, isn't that right? Those of you that have attended it. How many of you are turning a blind eye? How many of you know about your staff that are up partying? How many of you know about people in logging camps that are drinking? Whether you have a dry camp, wet camp, that they're drinking until 2 in the morning. This is something I hear all the time. Is that supervisors and managers saying, jeepers, I play hockey with these guys, and I'm not staying around, but they're drinking beer till 4 in the morning and then showing up at a shift. This changes it. You have actual knowledge of that sort of stuff going on. You have you have a choice. You can take action as required under the law and stop it, or you can risk your liberty, your financial freedom, your family, everything else. Okay, serious stuff. How many people here still engage in the old school practice of sending someone home who's hungover? Someone who smells of what you believe to be alcohol is being sent home. I guarantee a couple of things. One, in the end, it's condoning of their behavior, because what's the consequence for them? And you're jeopardizing their health and safety, and your, as we already talked about, the implications. But if they're an alcoholic, you're not doing them any favors. If they're an alcoholic, you're actually condemning them. There's only 2 things that happen with alcoholics. They either quit or they die. Absolute medical certainty. So if you have alcoholics in your company and you're turning a blind eye, you're not doing them any favors. You're harming them, you're harming their family. How many people in the room, and this isn't me up here, like, I don't mean to be on a soapbox, but the fact is I got limited time and I know that this goes on. Managers, owners that are drinking and drugging with their staff, okay? Stuff like that has very serious implications. So that's fairly rare, but it happens. Drinking on the job, so at the end of the shift, coming home in a crew boat, coming home in a crew, the bus, are you allowing people to drink in that situation? It's become, in many situations, this is an industry standard. It's a norm that this type of behavior takes place. You can't let it happen, not anymore. And hoping or wishing it'll go away won't work. WorkSafe, new investigation process. I'm just going to dabble in this very briefly. And again, I stress it's not intended to embarrass WorkSafe. It's to explain the fact that there are very serious penalties under WorkSafe. So, and again, many people aren't familiar with it. So the 2 mill explosions rendered in total $1.75 million in fines. One just over $1 million and 1 3/4. And Al, those were under appeal, right? Did they end up being appealed successfully? They're still under appeal? Okay, so they're under appeal, so we don't know where it's going to end up. But the fact is, those companies were fined. And in those cases, the intention of the Crown was to prosecute under Bill C-45, but that because of things that were in place in investigation at that time, it meant that the Crown couldn't proceed criminally. Part of the reason why, if I understand correctly, that WorkSafe's changed the way they investigate. So they have the administration process and then the investigative branch, but I'll leave the details to those folks. So from a provincial standpoint, not even thinking about criminal, that's what's at stake. It's very real. So just before we get into the successful program, we're talking about that, and then we go to the pigeonhole stuff. I'm going to give you 2 cases from British Columbia, and this is the law in British Columbia. So for those of you that are currently purchasing alcohol for employees, this will resonate with you. And whether it's a Christmas party or a social, it really doesn't matter. First case is called Jacobson versus Nike. How many people here have heard of that? Okay, so a few people. So Jacobson versus Nike, 21-year-old male working for Nike Canada out of Vancouver, actually in Burnaby, working at the warehouse setting up the display for the trade show that was taking place at BC Stadium. And they worked 8-10 hours, however long it was, at the warehouse, and then they drive to BC Stadium to set up their trade show at the booth. The supervisor, being a nice guy, brings some hot dogs and beer down to the stadium for the employees to drink. Not so much so that these people were getting absolutely hammered. And in fact, there was contradictory evidence as to how much alcohol had been consumed by the employees. In any event, what this young fellow, 21-year-old Mr. Jacobson, had between 6 to 10 beer over a 6-hour period. So, and it was demonstrated that he didn't guzzle them all at once. So it's not as though he was really impaired when he left. So he left the work site, that being BC Stadium, and went to a pub and had some more beer. Went to another pub and had some more beer. Went to a third pub and had some more beer. On the way home to Coquitlam, he lost control of his vehicle, single car crash, paralyzed from the neck down. So he'll never walk again, he'll never have sex, he'll never have children, his life is effectively over, 21 years old. So the judge, who thinks that Nike should be liable in that situation, by the way? Anybody? Really? So everybody in this room doesn't think the employer has responsibility. Well, if you're just shy and not willing to jump up on this one, I can tell you, and you probably know the answer, the court found against Nike because they introduced a known hazard to the work site, right? So drinking and driving is a very well understood and recognized hazard, and the court had this 21-year-old paralyzed man and a multi-billion-dollar Nike, and the judge in that case decided that the application of the law to the facts at hand favored the person who was injured. So that was 10, 12 years ago, and that is the law today. How many people here think that you should be on guard for impaired driving? Everyone thinks, you recognize that. How about impaired dancing? Huh? True story. Vancouver-based case, another one. It's Alexander Holborn. I don't know if there's any lawyers in the room or folks that know Alexander Holborn. A guy my size, a senior associate lawyer, is leading a number of junior associates at a function. They're actually fairly significant piss-ups and out of date, not keeping in step with the liability they're facing. So they go to a club that's sponsored by the company that are buying alcohol for their employees. A group of employees leaves this particular Yaletown club and goes to another pub where they continue drinking and dancing. Big guy falls on little woman, causing head injury. $6 million. That's the law in British Columbia. So any company intending to continue the practice of purchasing alcohol for employees, check your insurance with your insurance company. See whether or not it's covered. My guess is impaired dancing probably isn't. So for those companies that have learned the hard way, they provide a path, not of what to do, but what not to do. So in terms of a successful program, and the, let's see, you have to start off with properly written policy, fundamental that the folks in the room, in your company, understand that policy. You have to convey it, communicate it effectively, holding crew talks. Your supervisors need to be trained properly in terms of fully understanding what the implications are. Understanding how important it is that each step that is required, that it be done properly. There are no shortcuts in this process. Once you understand, and for those of you that have gone through it, you learn something new every day, but once you understand how to do it, it truly does become simpler. And I know I've spoken to some folks last night who have programs in place, it's running smoothly. The startup typically isn't particularly smooth. EFAP, do we have any EFAP folks here? Representatives from EFAP? EFAP plays a vital role in the process in terms of helping people who need assistance to get better. The objective, and for again those of you that know me or met me before, this will be a familiar term, and the objective is rehabilitation, not termination. The objective of workplace drug and alcohol testing is safety. It's not to enforce criminal law. It's not to enforce moral standards. It's to improve workplace safety. As an investigative tool, it's second to none in assisting folks who need help, even if they don't want to take that help, because it's a legal and effective means of proving conduct. Now, from a legal perspective, what employees do on their own time is none of the company's business. Everyone agree with that? Right? Okay, so it's not the employer's business until the conduct off work impacts the employer's interests. And then it becomes very much the employer's legal right and, in fact, duty to ensure that people are fit for duty. So as I mentioned before, I thought I only had 40 minutes, and we're ahead of schedule. So Gerard, we'll go with the pigeonholes now? We want to do that? Okay. So, legal requirements of a company before a drug test can be required. Now, if I understand this question, is it program related or specifically related to a test? So I can address it both ways. Okay, so the typical testing scenarios are post-incident. So there's been an accident, injury, near miss, property damage, environmental damage that exceeds a particular threshold. And the old way that drug testing was carried out is that if that happened, then you tested. The law doesn't support that approach anymore. Not only must there be an incident of sufficient gravity, you have to be able to demonstrate that the person who you're asking to test was directly involved in that causal chain, the link, okay, and that environmental factors were ruled out. So, for example, I had a client a number of years ago who was driven by a policy, he liked his policy. There was an accident that took place in the parking lot where one of the employees' cars was hit. She was up at her desk working at the time that she was required to go for a drug test. Does that make sense to anybody in the room? It certainly shouldn't. She had nothing to do with the fact that her car was hit in the parking lot. But the property damage was sufficient to trip the investigation, but only those people who are directly involved in the causal chain can be considered for testing. The other typical situation is a for cause or reasonable cause test, and where people are appearing or presenting at the work site showing the signs of impairment. I stress that drug and alcohol testing is an investigative tool. It is not meant to diagnose. People, supervisors should not engage in that kind of behavior, diagnosing or accusing. We've had real life cases where undiagnosed diabetics, head injuries, stroke, heart conditions, where the person is exhibiting signs of impairment, they're removed from the work site, the interview starts, and it's actually determined that what the supervisor is looking at is not a drug or alcohol problem, but a medical condition requiring immediate treatment. So this touches and concerns the whole issue of proper training for your supervisors. Now, for those of you that the legal requirements of a company before a drug test can be required, that first question, would someone please help me flesh out details on that? So the question, for those of you that didn't hear, is apparently what I'm saying sounds contradictory, is that you have a legal duty to act to remove that person, and the question is, or point is, then how do you do that without accusing? The way you do it is specific objective observations concerning speech, odor, behavior, and appearance. So the person may be slurring their words, they smell what you think is alcohol, whatever the factors are, you document that and let the drug test determine whether or not the drug or alcohol use was the underlying cause. People get themselves into trouble if they walk into a situation and start making accusations. You're drunk, for example. And you do that in front of a group of people, and then if you're unable for whatever reason to prove that that person was in fact impaired by alcohol, now you've just opened yourself up to liability for defamation of character. You could be sued for hurt feelings. So, and I'm not making this stuff up, that really does happen. So the point being is that don't accuse, investigate, document, let the testing process, as part of the overall investigation, make the determination. Well, there's a difference between observing and documenting and stating an assumption or making an accusation. So if a person is exhibiting signs of impairment, say for example they're an undiagnosed diabetic or a diabetic that their insulin levels are off, they're going to have a weird odor coming off their breath. It's acetone. They're going to have behavior very consistent with alcohol impairment. So it would serve no purpose to accuse that person of being impaired by alcohol, calling them drunk. Just document what it is you see, remove them from the work environment, secure the site, making it safe, and then start to do the investigation. Is that better? Yeah. Okay. Any other points to raise about that aspect? If you're wrong, so the question is, what if you're wrong? So if a person's exhibiting signs of impairment and you properly observe it, document, have a witness, and you acted reasonably, and you didn't accuse anybody, and you didn't make a diagnosis yourself. So unless you're a drug recognition expert, you shouldn't be engaging in that. And if you're wrong but you acted reasonably, there are no legal consequences. Okay, so I mean, I say no, it doesn't mean that there wouldn't be an attempt to do so, but you have a legal duty to ensure a safe workplace. You've got to remove hazards. You've got to go and find them. So in fulfillment of that duty, under various legislation, you're carrying out you're carrying out what you were supposed to be doing. So if a person is exhibiting signs of impairment and the drug and alcohol test is negative, what would be the next step in the process? Absolutely. Who said that? Yeah, so probably a medical investigation to determine the cause of the impairment. Anything else on this one? Yeah, go ahead. Oh, they're told. So impairment is, when we use the word impairment in this context, and this is a training point, a coaching point, it doesn't matter why you're impaired. If you didn't have any sleep the night before, should you be operating a loader? No. If you had a new kid at home, sorry, a baby at home, and screamed all night, and no sleep, stress, you have a cold, should you be at work? No. Right, so impairment, the drug and alcohol testing is to determine whether or not the impairment is caused by drug and alcohol use. So for example, maybe you didn't hear the question, but the question was whether or not you're impaired if you're having a diabetic coma. Is that it? So absolutely you're impaired. Doesn't matter why you're impaired, you're not fit for duty, whether it's lack of sleep, illness, what have you, or alcohol and drug use. You can be charged for impaired driving if you're a diabetic and you get behind the wheel and you knowingly don't have your blood sugars balanced. You can be charged for impaired driving when you're fatigued, because impaired is different than, in the criminal context, impaired just means that. And then there's a separate charge about related to consumption of alcohol and having a breath alcohol content over 0.08. Does that answer the question? Good. Anybody else? Let's get to some life, get some life going in this room. Nothing? Nothing on that first one? Okay, how about testing in remote locations? Is that number 2? So some of the clients, in the room, in fact, are looking at or are doing, offering testing carried out by contractor supervisors. So for contractors in the room, are there any in the room that are doing the testing themselves or the collection? No one yet? It is a problem, it definitely is. If you're up in a cut block and you're 5 hours away from the nearest collection site, you're facing, as a contractor, significant monetary consequences if you've got to shut down the job site and transport that person in for a drug and alcohol test. So the answer, or one response to that, is to carry out the collection and screening test in the bush on the job site. So you've got issues you've got to address there, one of which is privacy. And that's definitely a factor. But there are products available that will allow you to do on-site quick tests, both for drugs and alcohol. The alcohol test is a saliva-based test. The product's called QED. Super simple, easy to use. While it provides an indication of the blood alcohol level, It can't be relied on. No screening test available in Canada can be relied upon for making disciplinary decisions. There's a known false positive rate and a non-specified false negative rate. Okay, so quick tests, they have a place, no doubt of it. They save money and time, but the legally recognized process requires lab-based urine testing. Any comments or questions about remote testing? Okay. Okay, what happens enforcement legally if someone refuses a drug test after an incident? Well, there's case law from across Canada that demonstrates if what the employer does is seen as being unreasonable, that the employee, union or not, can refuse to do a drug test. Okay, so the key word, the linchpin here, is reasonableness. So proper training, properly investigating situations, not jumping to conclusions, following your policy and the law. So let's say that that's taken place. So the accident or incident was serious enough to trigger an investigation. Investigation determined that the person's actions were directly related to the accident, and so their act or omission, they did something they weren't supposed to do, or they didn't do something that they were supposed to do. Got that picture? So there's a link between the injury suffered or the harm suffered and the person's behavior. So that's tick that box. And then finally, is there environmental factors outside of the control of the employee that caused the accident? And one of our southern BC clients, and that incident was, it was a picture on the BC Forest Safety's, the newsletter. They had a double failure of hydraulics, and the thing rolled down a hill. Very expensive machine. So in that situation, you know, the triggering incident, it was literally $300,000 or $400,000 of damage. Well, clearly that's sufficient. That would justify an investigation. Next step, though, did the person's act or omissions contribute or cause the accident? No. In fact, you have to combine those two. It was a mechanical failure that caused it. No drug test. So even if a person were killed, even if there's $10 million damage, unless you can show that the person's act or omission is related to the harm caused, you can't do a drug test. I know that's not what the question asked, but I want to make sure that's really clear. So then if a person who has been involved in an accident and their act or omission caused it, and there weren't environmental factors that rendered that they were out of their control, and they refuse to do a drug test, suspend them, mandatory referral to a substance abuse professional is what my clients do, and the law is on your side. Union, non-union, makes no difference, okay? So you must act reasonably. Go ahead.
All the fatalities that are covered under workers' compensation in British Columbia, are they blood tested? Is the cadaver blood tested? Or?
I'm going to ask Al Johnson to answer that. Our post-mortem drug and alcohol test done on every fatality.
Hey Tom, we've got Chico Newell here who's with the coroner's service, so he'll be able to speak on that pretty accurately.
Short knows that I don't give short answers, but the short answer is yes. Whether or not you've got access to the, ultimately through perhaps freedom of information is something Mr. Yearwood might be able to speak to, but routinely toxicology is done in the case of fatalities. There are cases where it doesn't happen, where someone is injured and they see hospitalization over a period of time, that perhaps the specimens taken on admission to hospital aren't available or there wasn't screening done. It's fairly routine for alcohol to be done, but for other drugs it isn't.
So are you collecting samples for later testing, or are they tested right away?
If someone is admitted to hospital for medical treatment, the attending physician will have his or her interests in terms of doing testing. If it is that the person dies 5 days later or more, we don't become notified of it. The specimens are no longer retained, so we don't have them.
Okay.
And also there's the interval between the injury and the hospitalization. In some cases it's a matter of minutes, in other cases it can be an extended period of time, so any testing isn't necessarily going to be valid.
Okay, so that's in the Coroner's Act, right?
Yes.
So under WorkSafe, though, you folks can order testing, right? Okay. So I guess the short answer is, in most cases, yes. Would that be a fair one? Okay. So someone refuses to do a drug test where the employer has acted reasonably, whether it's union or non-union, they will have consequences that flow from it. If it's determined that the employer did not act reasonably, as happened in a situation in Halifax where a unionized employee and another person arrived at the job site late, safety sensitive, they're in construction, the supervisor came over and noticed the smell of marijuana in the vehicle. Instead of doing anything about it, he let those people carry on with their workday. 4 hours later, though, after having a discussion with his boss, with his supervisor, the boss said, "What the hell are you doing? You should have got those guys off the job site." And that's what he did. 4 hours had elapsed. The fellow said, "I'm not doing a drug test. This is not reasonable." And like 14 or 18 months later, the court agreed with him and he got reinstated with full pay. So that is a stark reminder of the need to have a good, well-written policy, administer it, enforce it, and if you make a mistake, accept the fact that you make a mistake and document how you're going to improve things to make sure it doesn't happen again. Any other questions regarding refusals? It certainly does happen. Okay, the one regarding unionized companies, whether union or non-union, that makes no difference with regard to human rights and the duty to accommodate. Is that a term familiar with most folks? Duty to accommodate. So you have to actually help people out to the point of undue hardship. And the number one factor in determining whether or not a company suffers undue hardship is whether or not you can keep this person working for you, without compromising safety. So it's what you hang most of it, your total approach on is safety. Okay, another aspect or consideration is cost. So, I've had financial institutions as clients in the past consulting, they never went ahead with the testing. But if you're the CIBC and you made 1.5 billion or 5 billion, whatever the number is, you're going to be held to a different standard in terms of what is expected of you to help that person, a person. So if you're a small operator, a contractor or company, a small company, union or non-union, while you have to take steps to help folks who are determined to have a need of rehab, don't think that you have to write a check for them, okay? But how am I doing time-wise? Because I got a great BC case right on point. 10 minutes. Okay, Okanagan School District 73. They have a favorite employee. He's a principal of a middle school or a school in Kamloops. And the employer sends him to Betty Ford, and literally Betty Ford, once, fails, twice, fails, 3 times, fails, relapses. Relapse is very, very common, okay? The vast majority of people will relapse. He did it 3 times. The employer said, okay, enough is enough. They terminated him. He took them to human rights and arbitration. In the human rights, the arbitration was held off until the human rights matter was resolved. And human rights said, you know what? You did a good job, employer. You did all that was reasonable. And that wasn't even in safety sensitive, okay? So that wasn't safety sensitive, so arguably the guy would get more chances. They spent $71,000 or $72,000 on the fellow. And this is 15 years ago or something. How many people here would be willing to spend that on a single employee? $72,000? Because the employer, in this case, hadn't thought through what they were doing, because they were trying to be good corporate citizens and not arguably thinking this through, they spent all that money on that fellow, didn't work out, and Human Rights Tribunal specifically stated that this now sets effectively a precedent and expectation as how you will treat other people in the same boat. So it's not an issue you want to back in, you want to think about it in advance. You want to have a policy, you turn your mind to it, come up with a threshold, express it to your employees, telling them what it is that you're willing to do. So typically this comes by way of, if you have EFAP, that's a big step. Everyone in this room should have EFAP. Through TLA, they offer a good package. There's a number of, that's why I was hoping there was an EFAP provider here. Someone, okay. TLA has a good package. And there's many other providers that can help you with that. But EFAP is a big step in assisting employees who need help. Second point, how many folks here are with USW or have USW locals? So while many people gripe about having a unionized workforce, the fact of the matter is in this case, it's fantastic if you have USW. USW has short-term disability that kicks in after 6 days. So the employee gets, is it 60% of their pay? So they need a diagnosis from a doctor, has to be a doctor, that says the employee has an addiction or is in need of rehab. They're eligible for that. So an enormous amount of weight is taken off the employer in terms of responsibility. A month, 28-day program at Edgewood is, I think, 12,000. Does anybody know different? So is that an accurate estimate, 12,000 bucks for 28-day? I'm being told now, and go ahead, sir.
Yeah, it's there are 28-day treatment programs. We feel like some people can hold their breath for that long. So it's about 6 to 8 weeks, predominantly 7 to 8 weeks. So that's why the cost is a lot different. It's a very nice setting. It's private, but it's 2 psychiatrists, whatnot. So it's 20,000. It's not cheap. We have outpatient programs. Like, for example, on Monday, there's a 3-month program for 5,000, and it's 9 hours a week. And it's treatment, but it's not residential treatment. So there's different continuums. But for your specific question, it's 20,000 for the 8 weeks.
For the 8 weeks, okay. Thank you. That's helpful. So how many folks in the room can pull out their checkbook and write it, to back that? Not many. So I know Edgewood has a very good reputation. They do good work. There are other facilities out there. There's publicly funded programs. The problem is you might have to wait months to get a person into those programs. So it is a balancing act that you want to think about before you go down that path. And let's just make something really clear. Whether you have a drug or alcohol testing program in place has got nothing to do with your duty to accommodate. Every employer in this room right now has a legal duty to accommodate people who suffer any disability. Right? So it's got, while our minds are turned to this because we're talking about drug and alcohol testing, the duty to accommodate is completely separate. Okay? Any other questions about human rights stuff? And that's like a 2-hour discussion all on its own.
Tom, I just have a question for you. It seems like we skipped over one of the items that got a high number of votes, which was all about medicinal marijuana. I was wondering if you could address that as far as goes with workplace programs.
Oh, you bet. So again, I mentioned before, doesn't matter what the cause of the impairment is. If you're impaired on the job site, there's a number of things that arise from that. The employer has a legal duty to remove any person, visitor, licensee, contractor. Doesn't matter if they work every day for you or they work once a year. Any person presenting on your work site impaired needs to be removed. Doesn't matter what the cause is. If you want to smoke marijuana, if you want to do crack, you're going to inject Percocet, Oxycontin, what you do on your own time, that's up to you. That's up to the employee. As soon as the person comes on that job site, though, they become your responsibility and liability. So medical marijuana, legal marijuana, when it's legalized, it does not matter. It's whether or not the person is impaired on the job site. So quite honestly, we could spend an enormous amount of time talking about the issue of marijuana, and it is real. I mean, it's gonna cause some problems. You don't need to let it cause you tons of problems. Communicate clearly to your employees. What you do in your own time is your business. Once you're on coming to work, it's my business. So if you're impaired from marijuana, you're impaired. Okay, so we're gonna launch, is there something else, Gerard, that we wanna get to before? So that's a good one. How do you actively screen for marijuana impairment? Well, you screen on the basis, you investigate on the basis of speech, odor, behavior, and appearance. Admissions of use, observed use, reports of use. These are factors that are to be considered. A positive drug test does not correlate to impairment. There is no means at this point in time of determining impairment on the basis of a drug test. So there are some folks out there trying to tell you different. Even if they're right, it's not a legal truth at this point, and therefore it does not matter. Okay, there's people working on a breathalyzer system for impairment from marijuana. Hope it works. That would be fantastic. Until then, we have to work with the tools that we're given, and the courts all across Canada, including the Supreme Court of Canada, has recognized drug testing as being legal. It's known to be effective. And the standard right now is lab-based urine testing. So if as a supervisor, owner, manager, you observe signs of impairment, you have a duty to investigate, you go through the investigation, you notice that the person smells of what you believe to be marijuana, they have bloodshot eyes, they have a joint in their pocket, partially smoked joint, and then they end up testing positive for marijuana. The court says an inference can be drawn. So you correlate the observed documented behavior, speech, odor, behavior, and appearance, with a positive drug test. Now, I don't know, the fellow from Edgewood, do you guys offer substance abuse professional services with reports to the employer? Okay, well, we'll talk after. So substance abuse professional is a recognized expert in the field. They are not, they're not EFAP. They assess that individual, and they're qualified to draw a conclusion. They do, it's typically a 3 to 4 hour process to be assessed, and it's upon their opinion that you will rely. So you have an employee, you document properly, they have a positive test, whatever it's for, Percocet, Coke, meth, whatever it is. Then this expert third party will give you an opinion, and that's good as gold. Union, non-union, makes no difference. So act reasonably, have a good policy, act reasonably, enforce your policy. If you don't, it's going to come back and bite you. Get proper training, make sure you know the facts. Act reasonably, and you'll be safe. Drug testing is legal, it's effective, it reduces accidents, and it will save you money. And that's me. All right, thank you very much.